Good morning everyone. Thank you for joining us today in person and online for our Aitken Partners breakfast, with today's seminar topic being intervention orders and family law. How do they interact? My name is Susan Ilias. I'm a principal lawyer in our family law team and I'll be today's moderator. This morning we'll be exploring the intersection between intervention orders and the Family Law Act. We'll cover key sections of the Family Law Act, including parenting and property provisions and how these interact with intervention orders. We will also look at the legal protections available to those experiencing family violence and the roles of the courts in managing conflicting orders and practical considerations for clients in these situations. Please feel free to ask any questions throughout the seminar, and the webinar audience, feel free to put your questions into the question and answer function and we'll answer those during the session too. So yell out or put your hand up, whatever, if you have any questions as we're going. So it's now my pleasure to introduce our panellists. Just here in front of me is Constantina Dimitriou. Constantina is a principal lawyer in our family law team. She has spent her entire career in family law, specialising in complex parenting matters. She also works as an independent children's lawyer in the Federal Circuit and Family Court of Australia. Constantina is also highly experienced in dealing with complex property matters that involve trust structures, overseas assets and family companies. Next to Constantina in the middle is Crystal Ong. Crystal is a senior associate in our family law team. She has extensive experience in family law related to relationship breakdowns, including complex parenting disputes and property settlements. Crystal also has significant experience representing clients in property and parenting dispute trials at the Federal Circuit and Family Court of Australia. And finally, down the end is Julia Poper. Julia is a lawyer in our family law team. Julia has valuable experience in complex financial, property and parenting matters, with a previous background in intellectual property, medical negligence and insurance litigation. So please join me in giving a warm welcome to our panellists. So I'll start off with Constantina, and in this section we'll be talking and Constantina will give us a rundown on understanding family law cases. So Constantina, tell us a little bit about the Family Law Act.
So it covers married couples, de facto and same-sex relationships. We look at parenting matters, property matters and divorce, but I think it's best to start with some parenting matters,
Yes,
Susan.
Absolutely. So what is the section that specifically relates to the parenting matters and children's interests in the Family Law Act?
So that's section 60cc of the Family Law Act. And we're making a parenting order. The court's main consideration is whether the proposed arrangements are what is best for the child in order for the child to be safe. So safety is the paramount consideration here. When we are considering parenting cases, we look at a core list of considerations. There are 6 of those that we look at as detailed in the Family Law Act when deciding what parenting arrangement is in the child's best interest. So I'll just run you through some of those considerations. So section 60C 2A, what arrangements would promote the safety, including safety from family violence, abuse, neglect or other harm of a child, and each person who cares for the child. We then look at any views expressed by the child. And Susan mentioned before that that I was an independent children's lawyer. So Susan and I are both independent children's lawyers. So we are appointed by the court in some of the most complex cases that deal with family violence or sexual abuse or extreme drug use. Drugs and alcohol. And there have been new provisions that have put in place last year which actually provide that when a child is 5 and above, we now have to speak to the child. So we get them in here and we have a little chat with them about what's going on at mum's house, what's going on at dad's house. But that has been, before we didn't necessarily have to speak to the children, but now that has been incorporated. We also have to look at the developmental, psychological, emotional and cultural needs of a child. and the capacity of each of the person who has or is proposed to have parental responsibility for the child to provide the child's development, psychological, emotional and cultural needs. We look at the benefit of a child of having a relationship with both parents or significant other people, such as like grandparents or as step-parents, those kind of things. And we also look at what is relevant to the particular circumstances of a child. So it's quite general, but there are many things that we have to consider. The other thing that I think is really important to mention in looking at a parenting case is that of parental responsibility. And parents have a duty, have duties and responsibilities in relation to children, and that is covered under Section 61B of the Family Law Act. So parental responsibility in relation to a child means all duties, powers and responsibilities and authority which by law parents have in relation to children. So what does that actually mean? When we look at joint decision-making power, so when mum and dad both make decisions for the child or the children, they both have to be making decisions with respect to major issues such as education, so like what school are the kids going to, religion, medical needs, those kind of things. And in some cases as well, there is an order for sole responsibility to one parent only. Susan, sorry, I've just gone on my rant there about parenting.
That's an excellent rundown of what we need to consider under the Family Law Act as far as the best interests of the child or children are concerned. With regards to property settlements, what are the key considerations in property settlements?
Yes, I will explain just generally how we look at a property settlement, and then it will tie in with the family violence overarching information that we're talking about today as well. So I probably should have said this at the beginning, but obviously when parties are separating or divorcing, it's a really emotional time for parties, and they just want to try and get through the process as quickly as possible. So that's a premise that we always have to think of in our mind when we have new clients that are coming in. But when we're looking at a property settlement, there is a framework that we have to try and go through to figure out what will each party receive as a result of a property settlement. So we look at Section 79A of the Family Law Act, which deals with the alteration of property interests. And this takes into account property that has been accumulated during a relationship or marriage or de facto relationship or same-sex relationship. So we have to look at the existing legal and equitable interests in assets, liabilities or financial resources. At this time, it's really important that we figure out what's actually in the property pool, and the way we do that is by exchanging financial disclosure. So husband and wife's lawyers swap their documents, and then we can determine what's actually in the asset pool. Something that a lot of people aren't aware of when they first come to see us, and this is something to take home from today as well if you don't know it, is you should be aware that at this step, the focus is of the property pool as at the date of the agreement, not when you're separated. So some parties come to us say to us, oh, we had this at separation. Well, we have to work on the days when, we have to work on the figures as at the date of the agreement when it's actually made. Sorry, let me just figure out where I'm at in my spot. Yes, it's Crystal. We have to figure out what is just and equitable. So what's fair is it fair for there to be an adjustment of the property interest between the couple? And then the next step we have to look at are what are the contributions that the parties have made during the relationship and after separation. So when we're looking at contributions, we look at a few factors. We look at financial contributions, which are made directly or indirectly by either party to the acquisition, conservation or improvement of any property of the relationship. So what does that actually mean? A client might come to us and say, well, I received a lump sum payment or an inheritance of $500,000 during the relationship. That would be a considered financial contribution. Also, for example, if a client walks into a relationship at the very beginning and they have a home unencumbered, that's an initial contribution that we will look at. So anything like inheritances, gifts, lump sum payments, they're all the financial contributions that we look at, as well as wages and salaries. Other contributions that we look at are non-financial contributions made directly or indirectly by either party to the acquisition, conservation or improvement of any property to the marriage. What does that mean? For example, if one party has done significant renovations to a property which has increased the value of a property, that's something that we definitely look at as a non-financial contribution. We also look at the contributions in the role of homemaker and parent. So for example, there's been a mum that stayed home, looked after the kids. That's a significant contribution that she's made on that part. So we look at all of those contributions and then we arrive at a percentage. So it might be 50-50. We determine what it is. But then we say, does there need to be a further adjustment to the parties' respective entitlements based off a range of other factors, which we traditionally call your section 75(2) factors, your future needs factors. So does the parties' percentage need to be pushed up or down depending on a party's future needs? And what are future needs? They're things like, you might have, we look at income earning capacity. So is there a disparity between what husband and wife are earning, or one partner and the other? Who has the children in their primary care? Does one party have another partner that they can financially rely on? Other things that we can consider is, does one party have the benefit of distributions from a trust moving forward that the other party won't have? So there's some of the things that we consider when we're looking at our future needs. But at the end of the day, we have to figure out whether the deal is a fair deal. And then there's two ways to settle it. We can either do a financial agreement or consent orders if we're not taking it to court, which we try and keep parties out of court as much as possible. So that's the spiel on how a property settlement works. But Susan, there's some other things.
Well, you've already touched on how the Family Law Act deals with family violence issues in parenting matters. So is there anything in the Family Law Act that considers family violence in property settlements? Because most people would think, no, it's just a financial decision that has to be made. Is there anything now that the courts or we as practitioners need to consider?
Well, yes, Susan, actually there is. From the 10th of June this year, there are some really major provisions that are being introduced into the Family Law Act. So we will now have to look at the economic effect of family violence. It'll be considered where relevant when making decisions about property settlements. And the amendments make it clear that economic or financial abuse may constitute family violence. So I'll just summarise what we need to have a look at. The new amendments will now look to introduce a detailed list of behaviours that constitute economic or financial abuse. The Act will require that the effect of any family violence to which one party to a marriage has subjected or exposed the other party on the ability of the party to the marriage to make contributions to the relationship be considered when assessing their contributions. And similarly, the Act also requires that the effect of family violence be considered when looking at those future needs. So those two things that I discussed earlier on. That's why I spoke about them, because they're really important in this case as well, in this scenario as well. So if we just have a look at some examples about what does that actually mean, we'll look at things like if there is an instance of violence where one party is trying to sabotage another party's employment, or whether there has been material wastage, so intentionally or recklessly, of the property or financial resources of either of the parties, or for example, if one party is really coercing another party to take on a liability or debt, Another example is if one party is unreasonably withholding funds from another party. So these are the kind of things that we will really need to have a look at closely because they will be taken into consideration. But overall, the court will need to consider the effect of the controlling or the coercive behaviour on a party, not the existence of family violence. So a finding that there is family violence that has been perpetrated would not necessarily lead to a greater award of property to the victim. So take it into consideration, but yeah.
Thank you, Constantina. And just very quickly, just so that we've covered everything under the Family Law Act that we do, what are the requirements to apply for a divorce? Because it's very separate to any parenting and property matters.
Yes, so just to let you know, I'm sure most of you know, but we have a no-fault divorce. So really the only requirement is that your marriage has irretrievably broken down. There's no prospect of getting back together. You have to be separated for 12 months. You can be living under the same roof as that time as well. If you're married for under 2 years, one of the new requirements coming in June is that you don't require counselling, which might be good. And I think another thing that's really important, just to cover things off in general, is when you're applying for a property settlement, upon the divorce order being made, you can only make an application for property proceedings 1 year after for a married couple, whereas it's 2 years for a de facto couple. So that's some important advice that we give. Generally, we tack on the divorce at the end, don't we, Susan? We try and do the property settlement first to figure out the kids, and then the divorce at the end.
There is that time limit of applying for a property settlement, as Constantina said, once your divorce order comes through. But if you never get divorced, then you can do property settlement at any time. There's no time frame, no time restriction.
Which we don't recommend.
No. So make sure they're real. Thanks, Constantina.
Thanks, Susan.
I'm going to move on to Crystal now and discuss the legal processes, criteria and the role of intervention orders and protecting individuals. So Crystal, just for those who don't know exactly what an intervention order is, can you please just explain what that is?
Sure, thanks Susan. So an intervention order is actually a civil order made by the Magistrates Court for the protection of a person, which can also include children in the relationship on the order as well. Just so everyone's aware, in Victoria it's IVOs, not a DVO, not an AVO, it is an IVO, so make sure you use that term correctly.
Yeah, thanks Crystal. You often hear clients say it's an AVO, but I think that's very much it's a New South Wales term for an apprehended violence order, but it's an IVO in Victoria. What are the protections that an intervention order can give someone?
Sure, so there are 9 paragraphs that are usually contained in an intervention order. Those paragraphs include an order prohibiting any family violence, any damage to property, a restriction on communicating or contacting with the protected person. There's also a prohibition on publishing anything on the internet about the protected person, being within 5 meters of the protected person, or being within 200 meters of any place that the protected person may live, go to school or go to work, and get anyone else to do anything that the respondent is actually not permitted to do. There are exceptions, however, that allow the respondent to do anything that is permitted by a Family Law Act order or a child protection order, attend mediation or counselling, and of course communicate through a lawyer or a mediator.
So Crystal, can you explain what are the considerations that, or does the magistrate take into consideration any Family Law Act orders?
Yeah, they definitely do. So if there are existing Family Law Act orders, particularly parenting orders, the magistrate must take them into account when deciding when to make an intervention order and what kind of conditions should actually be included. The court needs to make sure that any new intervention order does not directly contradict a family law order unless it's absolutely necessary to protect the safety of the protected person or a child. In instances where there is a conflict, the court can temporarily change or suspend parts of the family law order to prioritise the safety of the protected persons.
So Crystal, you mentioned that intervention orders contain exceptions that allow for the respondent to do what's contained in a Family Law Act order, despite there being prohibitions. Can you provide some examples of these exceptions?
So examples of these exceptions, they can include allowing the respondent to communicate with the protected person to organise to spend time with the children if there is a parenting order in place. It can also allow the respondent to attend places like a school, childcare, kindergarten, or changeover locations if needed to comply with those Family Law Act orders. Another common exception would be permitting communication through your lawyers, which it's probably the best case in those scenarios, or through a mediation service, even though direct contact ordinarily would be banned in those scenarios. These exceptions, however, must be carefully worded to make sure that there is compliance with the current Family Law Act orders so that you're not actually breaching the intervention order.
Thank you, Crystal. I'm going to move on to Julia now, and we will talk about how Family Law Act orders and intervention orders coexist. So Julia, can you just explain how do the Family Law Act orders and intervention orders coexist?
Yes, thanks Susan, and I'd just like to start off by saying, I'm going a bit off topic here, I am the most junior lawyer on this panel and everything that I've learned with respect to IVO matters has come from Susan, who has in excess of 20 years in IVO matters and family law. So this dynamic of me answering her questions certainly isn't a day-to-day occurrence. But anyway, I digress. So back to the question. So the Family Law Act is such that a family violence order and a family law court order can coexist. So specifically, Section 68Q of the Family Law Act provides that if a family law court order and an intervention order or a family violence order generally conflict, then the family law court order will prevail to the extent of that conflict. So it's most relevant, and I feel like I'm repeating Crystal here a bit, but you know, you might have an IVO on one hand, and then you've got ongoing court proceedings as well. And in those family law court proceedings, there are orders for the respondent to the IVO to spend time with the child, and the orders will stipulate how that time will occur. For instance, it might be, you know, every alternate Saturday from 12 p.m. to 2 p.m. supervised by the Family Contact Service. It'll be very specific. And so in those circumstances where the two orders do conflict, if the respondent to the IVO spends time with the children in accordance with that family law court order, they are not in breach of their IVO, but if they go out of that scope, then they certainly are. Now, notwithstanding that, Section 68R of the Family Law Act provides a power to a magistrate to intervene with family law court orders and to either, you know, suspend, discharge, or vary family court orders if there's evidence before the court that the children subject to those family law court orders are at an immediate risk. And that will often occur during an intervention order hearing where that sort of evidence is presented to the court. The magistrate will use that power to, as I said, to either vary, discharge, or suspend the family law court order, and then the magistrate expects that the parties will then revert to the Federal Circuit and Family Court of Australia to resolve that issue. Once that's resolved, the magistrate will lift the lid on that intervention, and the family law court orders will be reinstated. So to summarise, more often than not, the family law court order does prevail if there is conflict, but a magistrate has the power to intervene if the children are at an immediate risk.
Thank you, Julia. And just with regards to the legal protections and remedies, I'm going to turn to Crystal now. Crystal, what is the legal protection for people in family violence situations?
Sure. So Julia touched on it briefly, but if someone or yourself are actually at immediate risk of family violence, you can and should apply for an intervention order as mentioned earlier in the magistrate's court. And at that time, the magistrate can actually hear direct evidence from the applicant and make an interim order that provides for their immediate protection.
Thank you. So we've got protections under the Family Violence Protection Act. Are there any protections under the Family Law Act?
We usually have what you call denigration clauses. So most parenting orders will contain a paragraph that the parties do not denigrate the other parent in front of the children, or do not let any other person to denigrate them in front of the children. Orders can also be made for parents to be prohibited from physically disciplining the children.
So we know that there are, if somebody breaches an intervention order, that can come before the magistrate. It actually is a criminal offence. I'm sorry, I don't think we touched on that, but even though the intervention order is a civil order, if it's breached, the police then take action and charge the respondent with a breach of the order. Are there any protections we've said that. Are there any remedies for breaching the Family Law Act orders?
Yep. So in those circumstances where there's a breach of the actual Family Law Act order, a party can make an application in the Federal Circuit and Family Court of Australia for an application for a contravention. If those orders are breached, the hearing is actually a quasi-criminal hearing, and the penalties are similar to criminal penalties, such as a good behaviour bond or a fine, and in very serious circumstances, imprisonment.
Thank you. I'll turn to Julia now and we'll cover just some practical tips and considerations. So Julia, when you have clients giving you instructions about property and or parenting matters, and they advise you that there's been a history of family violence or that they're currently experiencing family violence, what advice would you give them?
Alright, so this is obviously quite a broad question, and I'd just like to preface by saying that family violence is a very complex and extremely individualised experience in the sense that no two clients will respond in exactly the same manner. You know, we get clients who are very forthcoming in relation to their experience with family violence, and then others who will only provide us with snippets of that sort of information here and there. So it's important that we as, family law practitioners, approach those situations with a degree of sensitivity and understanding, but also ensuring that we are making sure that our clients are entirely aware of every avenue of protection to ensure their safety within the confines of this system. So first and foremost, we would need to take careful instructions from the client, and in doing so we would need to be able to identify the indicators of family violence. So there's various legislation that defines family violence. So I'm just going to read from my notes here. So Section 5 of the Family Violence Protection Act defines family violence as behaviour by a person towards a family member of that person if that behaviour is physically or sexually abusive, is emotionally or psychologically abusive, is economically abusive, is threatening, is coercive, or in any other way controls or dominates the family member and causes that family member to feel fear for the safety or well-being of that family member or another person. Then the Family Law Act in Section 4AB also defines family violence as violent, threatening, or other behaviour by a person that coerces or controls a member of the person's family or causes the family member to be fearful. And I think on this note, I will just refer to the statistics of the occurrence of family violence because it is very common. Now, approximately 1 in 6 women and 1 in 16 men will endure family or domestic violence during their lifetime. Approximately 11.3% of Australian adults have encountered some form of family violence from their partner, and women with disabilities are 40% more likely to experience family violence than other women. So once we take our careful instructions from the client and identify that there obviously is some form of family violence occurring, it's important to firstly address their immediate safety, and that's really as simple as telling them and really emphasising that whenever they feel unsafe, they must contact the police. You might say, Julia, that goes without saying, obviously, but when we think about clients that have experienced family violence, it might be the case that their feelings of self-worth are quite low and their ability to trust people, perhaps particularly authorities, is severely impacted. So just, reminding the client that their safety does matter and reminding the client that, whenever they do feel unsafe, contact the police. It's not a matter of how large the threat is. Don't feel like a nuisance, just do it. And then there's certainly other ways that we can address their immediate safety, and that would again depend on our instructions and the context of the violence. So it might be the case that we advise that the client, change their passwords to emails or social media or block their abuser, their bank accounts, etc., etc. So again, it would all depend on the circumstances. And then of course we would turn to advising in relation to obtaining an intervention order against their abuser. And I'm not going to go through the nuances of what an IVO is because that's already occurred. Effectively, the advice would be, you can take out this order. It provides a set of restrictions that are intended to protect you, and there are legal consequences that will result if they breach those restrictions. They will be criminally charged, and then criminal proceedings will ensue thereafter. And certainly, we would also advise that we can assist in the preparation of that application, or we can direct the client on how to do it themselves. And certainly it would be up to the client as to how they, want that to occur. And then there's certainly ways that we can protect clients within the Family Law Act. So particularly in the context of ongoing family court proceedings, and particularly in relation to parenting proceedings when there's children involved. It might be the case that, there might be court orders for their abuser to still spend time with the children, right? So that means that there will be a degree of contact between our client and the other party in terms of changeover. So we might seek that changeover be supervised by someone else. And also we can extend that to protecting the children as well, because more often than not, they are protected persons within the IVO. So it might be the case that we seek that contact with the respondent to the IVO be supervised, and that can occur via supervised contact centres, or it can occur by someone that our client knows and trusts. And again, that would just be the preference of the client. And importantly, and if we think that the family violence is really significant, then we would be seeking that there be no time between the abuser and the children. And Susan was involved recently in a case that we received judgment, I think it was mid last year, was it? Mid to end. The case went all the way to, I think it was a 3-day trial.
3-day trial.
Yeah, 3-day trial. There was serious instances of family violence in that matter, and we represented the mother. There were 2 young children involved, and the mother actually filmed violence, so the violence that was inflicted upon her, but also the children, and that would have been really quite scary and distressing for her, obviously. And yeah, went to a 3-day trial. The father was cross-examined. I mean, his response was just ridiculous. He was coming up with all sorts of excuses, even going as far as to say as our client fabricated the videos when, but in that.
And Julia, just to make that, put it more into context, the case was about a change of residence case where the father wanted the children to live with him, despite the fact that there was a history of family violence. There were intervention orders for the protection of the children for a number of years, but he was still seeking a change of residence. The mother was seeking for the children to live with her with no time with the father. Sorry, Julia, go.
No, you're fine, Susan. I mean, Susan ran the matter, not me, so she's probably the better person to explain. But yes, and the judgment was really interesting read, and certainly Susan did a really good job, and the judgment certainly indicates that as well. So it was a really good outcome for the client. Obviously, all the years of abuse that she had experienced, as well as the children, the court just decided that it just wasn't in the best interest of the children to have any sort of relationship with their father.
That's very unusual though, when there are cases of intervention orders and Family Law Act orders that coexist and run side by side. It's not a common occurrence for there to be no contact with the father, but in this particular case, the orders were made by the judge for the children to live with the mother. She had sole decision making for the children and absolutely no time with the father. So all contact with him was cut off. But look, it does help to have the intervention order proceedings. It does help to have the intervention orders in place when these matters are coming before the family law courts. So Julia, is there anything else that you want to
Yeah, so I was just going to finalise that and just quickly refer to the fact that there are various support services that we can certainly recommend to clients. And again, that would depend on the circumstances of the violence that they've disclosed, such as, I don't know if you've heard of Orange Door or Safe Steps or 1-800-RESPECT. So Orange Door is particularly good for, formulating a safety plan for the client. There's also counselling services, etc. So ultimately, obviously that's just a very brief rundown on how we would approach these matters, but the reality is it would entirely depend on the circumstances of the family violence, and we would have to tailor our advice accordingly. And certainly in any event we would be advising in relation to an IVO, which do certainly work. But just to conclude, and I think we as family law practitioners need to acknowledge that there is, in some instances, a bit of a tragic irony in this system, in the sense that, and I think I can speak on behalf of my colleagues here, that we have encountered clients that when you do advise in relation to an intervention order, their response is words to the effect that they fear that the IVO will actually agitate their abuser and provoke violence in that regard, and that's quite shocking. But the reality is our client knows the behaviour patterns of their abuser better than we do, and certainly better than the system, and they might be correct in that regard. And when we think of family violence, it's certainly all about control. And if you think about intervention orders and what Crystal went through previously in relation to the restrictions, it's intended to act as a deterrence and certainly take away that control. And then when you think about that on the backdrop of ongoing family law proceedings, where there might be family law court orders that also take away the control of the abuser in the form of, there might be parenting orders that extremely limit the time with the children, or provide the abuser has to engage in all these behaviour change programs, etc. And then at the end of the day, depending on whether that deterrence aspect of the IVO works, would depend on how the abuser responds to that, the taking away of the control, whether they heed that deterrence or whether they react to take back that control. And I've personally never seen that, but I know that Susan has been a part of a case in which that occurred, and it was a very tragic instance of family violence. So I will just like to pass this on to Susan, but also just provide a disclaimer, obviously, that it is quite a horrific instance of family violence.
I was involved in a case a number of years ago where I was appointed as the independent children's lawyer for 4 children. They were aged between about 4 years and 13 years of age. They lived with the mother, and they were spending time with the father. It wasn't supervised, but it was only daytime. The children became quite fearful because he was telling them that he was going to kill their mother. I was appointed early on in the family law proceedings as an independent children's lawyer to represent the best interests of the children. The first time that I was due to appear, the court had ordered a report to be done by a family consultant. For those of you that don't practice in family law, a family consultant is a psychologist appointed by the court that interviews the parents, they interview the children depending on their age, they write a report and they make recommendations based on those interviews. And then it's handed to the practitioners and the court. So my first appearance in this matter, the family report was due to be released. But given the concerns that the family consultant had, she called a meeting between all the practitioners. So the lawyer for the mother, the lawyer for the father, and me as the independent children's lawyer. So we spoke to the family consultant, and she was seriously concerned about the children's safety and the mother's safety. And we had decided that there would be no time. We're going to cut off all time between the children and the father because of these threats that he's been making. So we went into court. The father refused to engage. He was quite agitated. He was pacing up and down the court corridors, and we went into court and advised the judge that he was just not going to engage. So orders were made for no time to occur between the children and the father. The next day, the mother had a hearing in the Sunshine Magistrates Court for an intervention order matter. She attended there, the father attended, he actually consented to an order being made against him. And she obviously thought, great, I've now got the protection that I need, I've got an intervention order. He can't come within 5 metres of me or the children, can't come within 200 metres of where we live or the children go to school. So I'm assuming she felt protected. She went to her lawyer's office, which was in Sunshine, and as she was leaving her office, the father had approached her and he stabbed her 17 times in the middle of the day in Sunshine, in the middle of the shopping precinct. She subsequently died of those injuries, and he obviously left the scene. Police found him and he ultimately pleaded self-defense, saying that she was the attacker. How that works, I don't know. She was stabbed 17 times. He did not have one mark on him. I was then called by the prosecution to give evidence in the Supreme Court in the murder trial. It went for probably about a week or 2 weeks. He was ultimately found guilty of murdering the mother and is now serving a life sentence in prison. But it just goes to show, we give clients advice about get this protection, get the intervention order, but at the end of the day, a lot of clients say, oh, it's not worth the paper it's written on. Well, unfortunately, sometimes it's not. And in that situation, that was just an awful outcome, obviously. The children now live with the paternal uncle, and their father's in prison and their mother has died. So, although the intervention orders and the Family Law Act orders do work and they can coexist, and most of the time they do work well, there are obviously instances where they don't. But it's just a matter for us to really assist the clients and try and identify when children really, or the mother really is, or the father is at risk, and to assist them and put the proper protections in place, whether it's under an intervention order or whether it's with a Family Law Act or both, a combination of the two. So I'm sorry to have to end on a really tragic note, but they do coexist. They can coexist very well. But sometimes, they just don't work, but you can't control what other people are going to do. So thank you for coming today.
Questions?
Question? Yes?
Or
Oh, I'm
questions from the
sorry.
room?
Questions generally. Does anyone have a question?
Sorry, Susan, just on that last anecdote.
Yes.
Just as a postscript that you
Sorry,
might
Shane,
know-
can I get you to answer the mic just for online?
As a postscript to that last graphic anecdote, I was personal friends living in the Macedon Ranges with Magistrate Stephen Mile. He heard that case.
Yes.
He related to me that the murderer was compliant in court, was polite, had consented to the order, and when he found out roughly 45 minutes to an hour later, the weapon that had been used had been by reason of the murderer running through a butcher shop and out the back door with a knife. That's how he obtained the weapon.
Yeah.
And the court went into some very heavy counselling in relation to that because it was of real impact.
Yeah,
So
absolutely.
good on you for being available to that case.
Thank you. It does have an impact. When the Shane, as you said, the magistrate heard about it 45 minutes after it had occurred. I got a phone call probably about an hour and a half after that it had occurred. The solicitor for the mother called me and she said that the father's just murdered the mother, and I had to ask her again, like, what? What did you say? It was such a shock that I just didn't quite understand, and then when she told me again that he'd stabbed her, it was such a shock. We went into lockdown, the police came. It does have, such a rippling effect, but Magistrate Milne is a very good magistrate, and he must have been shocked because interestingly though, that in the family court the day before, the father was quite agitated, and he was running up and down the court corridors and not engaging. But then he turns up to the magistrate's court and he's quite polite and he's saying, yep, I'll consent to an intervention order, denying the allegations, whatever, it's no big deal to me. And then, then that occurs. Yeah, thanks, Shane.
Susie, can you explain the effect of section 60I of the Family Law Act and whether it applies to property settlements?
60I of the obtaining a certificate for
Yes.
mediations. So section 60I, it does. It's most of the time it's with regards to parenting matters, that prior to making an application to the Federal Circuit and Family Court of Australia, the Family Law Act attempts to encourage people to negotiate rather than issuing proceedings. So for parenting matters, there is a requirement that parents engage in mediation, and if it fails, or if it's successful, or if they don't attend, then what's called a Section 60I certificate is provided to the parties, and you don't have to attend, especially sometimes the services determine that the matters are not suitable for mediation, especially where there are family violence issues and intervention orders involved.
Can I just add another thing? So there are requirements now, pre-action procedure rules, before we file for property or parenting matters. Parties do need to try and participate in mediation, and they're for parenting or property matters. There are forms that we actually have to fill out which say yes, they've tried mediation, or no, they haven't. So in a property case, for example, if we're writing to one party and trying to engage in mediation, the other party simply doesn't want to participate, we can file proceedings in court. So there are very strict requirements now, pre-action procedures before we file for parenting and property matters.
But the Section 60I is specifically for parenting. Yes.
Question around how best to keep costs down. You've talked about, I guess, parenting disputes and IVOs. What about when you're needing to go back into the federal court to go and challenge the current consent orders and the timeliness of that? How can people try and keep their costs down?
Should I ask Crystal perhaps to answer that?
Thank you. So in circumstances where you're saying law orders have already been made, the first thing you've got to do, as I always say, please speak to a lawyer, pay usually we have like an initial consult free of charge, but of course we need to probably have a more in-depth conference to actually review the previous material, review any new evidence as well, to make sure that we can actually see there is a significant change of circumstances before you make an application to court. Because in circumstances where you do not get the proper advice or have those things actually reviewed, evaluated, etc., you can find yourself in a worse off and more a worse off position where you've actually spent more money. So that's my advice.
It's also final property orders are quite difficult to set aside, so we have to rely on, pursuant to Section 79A of the Family Law Act, for example, there has to be a fraud or a duress, or a party hasn't disclosed, significant financial information. To bring those applications back to court, they're complicated. Likewise with parenting, as you touched on, we have to show that there's been a material change in circumstances in the parenting arrangement for final parenting orders to be amended. So they're complicated things to do, but they can be done. Sometimes they are expensive. So get the advice first. From Aitken.
We've got one from online. Hi there, you mentioned cases where contravention proceedings for breach of orders are made at FCOA, re family violence. How frequently is this exercised in your view, and generally what outcomes have you seen?
Oh, I'm happy to. Yeah, go.
Actually been in a lot of contravention order proceedings. Haven't seen imprisonment so far, but I would say it's good practice to file a contravention proceeding, especially when there's such a clear breach of those orders. In circumstances where, for example, in parenting matters where the time has been seized, you must diarise everything, have all those evidence, those text messages, have it drafted by a lawyer, please, before going in. Depending on the response of the other party, if they had a reasonable excuse or as to why they just weren't able to comply with the contravention order, or if there was just no reasonable excuse at all. I've seen there's a lot of circumstances where it can lead to, as I said before, a good behaviour bond, which I've seen, a fine that I've seen, or if it gets too complex, they actually make you initiate new proceedings as well. But as I said, it's really important to actually go for the application for contravention in circumstances where you've already got that evidence and there's that consistent breach of those Family Law Act orders as well.
But thank you everyone for attending and for listening and all your great questions. I hope that was informative for you, and we look forward to seeing you maybe next month. Thanks again.